Hi, I'm Carl Pearson, an editor of Video Newspaper, and in this edition I'm going to explain how a homeowner in states such as California can bring his or her own foreclosure action against the bank. The difference you have to understand exists between a judicial foreclosure and a non-judicial foreclosure. In New York State, we have a judicial foreclosure. So in order for a bank to foreclose upon a mortgage, the bank has to bring an action in court, and the process of obtaining a foreclosure and selling the property can take between 12, 18, sometimes 24 months. So that's a judicial foreclosure. New York State has the longest process in the nation, and it's done so deliberately so that people can't be thrown out of their homes right away. On the other hand, 29 states, including California as the most notorious, have a non-judicial foreclosure process. And a non-judicial foreclosure is basically where the bank has a pickup truck or a bus, and they have people on the vehicle with signs and mallets, and they drop the people off in front of a house to be foreclosed on, and they knock a sign in the ground announcing that the property is going to be sold. They may file a piece of paper somewhere and then auction off the property perhaps 40 days later. So that's a non-judicial foreclosure, and that's really what I'm talking about in this video. So 21 states have no such thing as a non-judicial foreclosure. 21 states, including New York, have a judicial foreclosure proceeding. Now, when you have a judicial foreclosure, the defense of a foreclosure action is really to try to prevent a wrongful foreclosure by asserting whatever defenses, offsets, and counterclaims that the homeowner may have against the bank, so that the homeowner obtains recovery by offset, meaning a reduction in dollar amount, because of certain wrongdoing that the bank may have been engaged in. Defenses should be asserted so that sometimes the bank really doesn't have the right to bring the foreclosure action at all, such as when they don't have the original note and mortgage and somebody else may have it, so that there's been recently a recognition that that is generally a defense to a foreclosure action. And there are other defenses and counterclaims that should be asserted under various federal and state statutes. The two most important ones are RESPA and TILA, the Truth in Lending Act, and the Real Estate Procedures Act, Settlement and Procedures Act, RESPA. So litigation in foreclosure states is used to stop a wrongful foreclosure. But in the non-judicial states, there isn't any such action, so that the bank takes whatever it wants without court supervision, and in some cases there is a wrongful foreclosure which requires the homeowner belatedly to pursue. If a borrower has legal issues that he or she would like to use to stop or offset a bank's foreclosure proceeding, there seems to be no way to do so in a non-judicial foreclosure state other than to sue for wrongful foreclosure after you lose the property. But if you bring the same claims in a lawsuit before the wrongful foreclosure takes place and try to stop the foreclosure, you have the borrower bringing a foreclosure action against the bank to foreclose the bank from exercising its right to foreclose under the mortgage. This can be a powerful tool for homeowners to stop the sale of their property and to get the bank to enter into a reasonable modification agreement. The bank should be interested in doing this, especially if the litigation delay by reason of the homeowner's foreclosure action against the bank would tend to make the property non-performing, that is, not producing monthly mortgage payments for the bank for perhaps a year. Here are the elements of a homeowner's foreclosure action as I spell them out in my website, and the website address is non-judicial foreclosures.com. Everything is run together except there's a dash after non-judicial foreclosures.com. First of all, you need an order to show cause, which is a notice of motion requesting a temporary restraining order and a preliminary injunction prohibiting the bank from selling the property at auction. This has to be supported by an affidavit of the homeowner, perhaps the homeowner's spouse, and perhaps the attorney that's bringing on the case. Then you have to have a memorandum of law in support of the motion to show the judge the legal reasons why the judge should grant the temporary restraining order, the preliminary injunction, and in the long run why you should be able to prevail, at least arguably, and have a good chance of prevailing. And there are doctrines that you have to meet in order to show how likely you are to win the case in order for the judge to grant this relief preliminarily. Then you want to have a proposed order for the judge to sign, and you probably in the state are going to want to file a lease pendens to notify the world, and particularly anyone the bank might try to sell the property to, that they take this property subject to your lawsuit. So that is basically the documentation that's needed to be prepared for a homeowner to foreclose against the bank. Now, here are the economics behind foreclosures. Most foreclosures go undefended and cost the bank only $3,000 or so in legal fees and court expenses, other than the costs of sale of advertising and selling the property at auction, and the loss of mortgage payments while the homeowner is occupying the property but not paying the mortgage. The bank wants to either get its money back to invest in other real estate or have the property become performing once again with the monthly payments. 2. When a bank's foreclosure action is defended vigorously, the bank has to hire a new team of lawyers. The original team's expertise was in preparing and filing foreclosure actions and motions for default judgment and having the property sold at auction. But when a homeowner actually defends against the foreclosure action and alleges that the bank was involved in wrongdoing, the bank usually has to hire a more expensive law firm to deal with what amounts to a lawsuit, a counterclaim, for wrongdoing against the bank. This can be very, very expensive, ranging between $400 and $700 per hour for each lawyer involved in this major law firm that'll be hired, with perhaps 100 hours or more to be put in on the case unless a settlement can be reached. 3. The settlement, of course, is to enter into a modification agreement of the type the borrower wanted, but the bank refused to do before filing its foreclosure action. But now the costs are going to jump from $3,000 to perhaps $70,000 or more, and the bank may well decide, and usually should, that it's better to give a modification agreement and settle the case, stop the legal fees, and bring the property back to performing status, although at a reduced monthly rate and for a reduced principal amount, with a waiver of accrued interest, default interest, and attorney's fees. The same thinking by the bank should occur when faced with a homeowner's foreclosure action against the bank, assuming, of course, that the lawsuit has merit. If you want some more information about any of these topics just discussed, please visit my website at non-judicialforeclosures.com or give me a call at 212-307-4444. Here's the website address. I'm sorry, this is my trademark, and you can find all my videos at that address. My name is Carl Pearson. I'm a lawyer who litigates in the areas of antitrust, civil rights, intellectual property, foreclosure defense anywhere in the U.S., and other commercial litigation. You can find my video newspapers on YouTube by searching for my trademark, CEPersVid. Thank you.